Please, your lordship. Lordship, I 38 lordship. Finally, adjourn for today, lordship. Engage counsel Mr. G. So there is not well, lordship.
Item
38 lordship.
Next. It may be fixed, your lordship. I think 38, your lordship.
give a date, Mush.
The vacation. Pleasure, lordship.
Wait, please, your lordship, I beg to.
Item number 37. Yes.
Urgent this matter
You are for?
for the petitioners, appearing on behalf of Mr. A. Goel.
You have taken consent from the other side.
Yes, ma'am. Much of. My lord,
Can I-
any date may be fixed.
Can-
May I please your lordship? Lordship, I am praying for a listing for withdrawal.
Which year? No, no, you got bail by this court. Okay. Okay. Bail, I think I have rejected. Yes, one of.
Look, this criminal revision is against the judgment and order dated 29/2011, passed in a criminal appeal,
Mm.
whereby the judgment and order passed by the CJM convicting the petitioner for 6 months and imposing a fine of 50,000 under the Copyrights Act. My lords. The offense under which he was convicted, Section 63 of the Copyrights Act. The book list, my lords. Now, my lords, 6 PWs were examined, my lords. The matter, and my lords, if my lords comes to the judgment and order, it would appear, my lord, the judgment is perverse because it's not based on any evidence, my lord. Before I take my lord to the judgment, if my lord kindly peruses the act for a moment, my lord.
63.
Offenses of infringement of copyright or other rights conferred by this act.
Mm.
Any person who knowingly infringes or abets the infringement of A, the copyright in a work, B, any other right conferred by this act, so and so, shall be punishable with imprisonment for a term which shall not less than 6 months, but which may extend to 3 years, with fine which shall not be less than 50,000 rupees, but which may extend to 2 lakh rupees, provided where the infringement has not been made for gain in the course of trade or business, the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term less than 6 months or a fine less than 50,000. Now, my lords, 63 provides the person who infringes. Now, the term
Or abets of infringement.
or abets infringement.
Uh,
Now, infringement has been
Define.
defined in the act, my lord. My lord comes to section 2M. So we are concerned with a cinematograph, my lord.
Okay.
It was a VCD, my lord, Ringa Ringa Mon by Zubin Garg, my lord. It's a VCD. 2M, my lord. My lord has it. No? Infringing copy means we are concerned with 2,
Two.
Roman 2.
Mm.
In relation to a cinematographic film, a copy of the film made on any medium by any means. Now, my lord, 63 provides, my lord, if anyone makes a copy of a film which has a copyright, he commits a crime under section 63. Now, my lords, therefore, my lords, to prove that someone has committed infringement of a copyright, my lords, the burden is on the prosecution to
Yes.
prove it, my lords. And how will the prosecution prove it, my lords?
Mm.
Well, at least, my lords, the VCDs, the purported VCDs or CDs which were seized, purportedly seized at the premises of the accused, my lords, had to be proved at least. It has to be exhibited and it has to be proved. Only then the honorable judge can come to a finding that this is the original and this is the pirated film, my lord.
Yes.
But with all due respect, my lord, although the learned CJM, my lord, had given a detailed judgment, but the prosecution did not even exhibit the CDs which were seized by the
Who are these prosecution witnesses?
prosecution witness, my lord. Number one is the brother of the accused. Number two is the informant. Number three is one neighbor. Number four, my lord, I'll go through the prosecution judgment. So my first primary ground, my lord, is that, my lord, lordship is aware, my lord, to constitute infringement, there has to be a satisfaction that this, which is a purported pirated copy, is a copy of a videograph which is
Something
otherwise as
original.
a
Something,
Yes.
it's a infringement of a cinematographic film.
cinematograph.
So you want to say there must be first proof that this is existence of a
Yes.
cinematographic film, and this is its copy.
Like, my lords, the copies were the CDs which were seized, they were not exhibited, leaving alone the proof of the contents. What ought to have been done was, my lord, in all due respect, my lord,
Now, from where the learned magistrate concluded that this is a copy?
that finding is not there. That finding is not there. It is only on the informant's statement that he went to the place and he found pirated copies of purportedly the pirated copies of the copyright. my lord.
Only on oral,
Yes, yes.
only on oral evidence.
Yes.
No,
And
nothing
the
is there.
second ground, my lords, second ground, with all due respect, my lords, the learned CJM, my lords, by relying on a judgment of the Supreme Court, had came to a finding that the proof of copyright is not required. Now, what had happened in this case, my lord, the informant who claimed to have DG Music, NK Productions, my lord, who claimed to have a copyright on the cinematographs, did not produce any document with regard to the copyright, my lord.
To prove of
To prove that he had copyright.
copyright.
First, he has to have copyright.
Copyright.
Only then it can be infringed. Now, that document was never seized by the police. The learned CJM came to a finding that since he has made a statement orally that the cassettes, the VCDs, there is a statement saying that it has a copyright, so that would suffice. So no document was adduced to prove that he had a copyright. And to prove that the owner of the copyright is not required, a judgment of the Supreme Court was relied upon. Now, before coming to that judgment, my lord, the second limb of argument, lordship would kindly come to 52A, my lord, of the
52A.
A.
Yes.
Particulars to be
Just a
included.
minute, just a minute.
I'm so sorry.
52
A,
capital A.
capital A, my lord. A,
52A.
my lord. Particulars to be included in sound recording and video films. No person shall publish, lordship would take note, publish a sound recording in respect of any work unless the following particulars are displayed on the sound recording. We're not concerned with sound recording. Number two, my lords. A person shall not publish a video film in respect of any work unless the following particulars are displayed in the video film when exhibited on the video cassette or other container thereof, namely. If such a work is a cinematograph film required to be certified under such and such, under the provisions of the cinematograph, a copy of the certificate granted by the Board of Film Certification under Section 5A of that Act in respect of such work. B, name and address of the person who has made the video film and a declaration by him that he has obtained necessary license or consent from the owner of the copyright in such work for making such a video and film, and name and address of the owner for the copyright in such work. Now, what I understand, my lords, 52A provides, my lord, two, that if someone publishes a cinematograph, my lords, there has to be a declaration amongst others that he has the permission of the person who owns the copyright. Now, any violation of 52A would not attract 63, but it would attract 68 A, my lord. Lordship may kindly turn to section 68A, which has been amended in the year 84, my lord, pursuant to coming of the 68A.
Sixty-eight A.
68A. Penalty for contravention of 52A. I just read 52A, my lord. Any person who publishes a sound recording or a video film in contravention of the provisions of section 52A shall be punishable with imprisonment, which may extend to 3 years and shall also be liable to fine. Now, my lords, with all due respect, my lords, 63 and 68A operates in two different fields, my lord. 63 provides that if there is an infringement, and by going through the meaning of infringement, that a person, if he only copies it, that is enough to attract section 63. Am I clear? Ma'am?
Yes.
And for 68A, there has to be a contravention of section 52A, which I've just read. And what
Now this person has been punished under section 63.
63. 63. Now, my lords, 60
Charges were also framed under 63.
63 charges framed under 60. Now, my lords, to attract 68A, 50, I'm so sorry, 52A has to be violated, my lords. And 52A clearly provides that when you publish a cinematograph, the declaration that you have taken permission of the copyright holder or the person who has the copyright is a sine qua non. And if you don't do that, you are liable to be punished under 68A. Now, the judgment, the Supreme Court judgment on which the learned CJM had relied and came to a finding that the owner of the copyright did not prove that he has a copyright was a conviction under 68A. Necessarily, why, my lord? Because if someone is penalized under 68A, the person who has the original copyright may not be traced out, because there is a clear direction under 52A that he has to declare that he has taken permission of the original. The moment he does not take the permission from the original copyright holder, he commits an offense under 68A.
68A.
It was under such circumstances the Supreme Court had ruled in that judgment, 96 judgment, that if it is a penalty under 68A, a person need not prove that he has the copyright and it was infringed because of the provisions of 52A.
So according to you, that judgment is not relatable to section 63.
Exactly, my lord. Exactly, my lord. Now, these are the two limbs of my argument, my lord. First, my lord, to convict someone under section 63, my lord, it has to be proved by the prosecution that the copyright has been infringed. And how it is infringed has been provided by the Act itself. That a person has to make a copy of the original cinematograph which has a copyright. Now, to come to that satisfaction and come to that finding, the seized, purported, pirated CDs ought to have been exhibited before the court, and the contents had to be proved, my lord. But people would agree, my lord, that is admittedly not done, my lord. No one even had a look at the CDs, my lord. That's the first limbo.
There may be something different in there.
Yes, yes, exactly. Unless and until the contents are proved, my lord, what is there in the CD. I'm not coming to 64B, all that, my lord. That is, even before that, my lord.
Where is the complaint or FIR, something like
FIR, my lords, page 17.
70 of?
17, my lords, page 70. And in the FIR, it's not the police who seizes the VCDs, my lords, it's the informant. He goes and he seizes I'll read the FIR, my lords. The translated copy, my lord, page 17. May I read, my lord? Third, most respectfully beg to state that VCD of modern songs manufactured under the banner of my NK production, namely Ringa Ringa Mon, released on 7/4/5, having come to know that the said VCD has been pirated by Delight Cyber Cafe situated at Jorhat, Bahadur, Gaubura Road, informed the police, and having informed the police, we ourselves conducted search in the said institution, along with other adjacent CD electronic shop before the police came and recovered several duplicate VCDs. We recovered VCD of Ringa Ringa Mon, Lajuki Mon, Bogi Tora Tejimola, and many other CDs in English Hindi films. Also seized from the house of the owner, the said Delight Cyber Cafe, in cooperation with police, 4 computer set, 2 CD copier machine, and many blank CDs and stickers used in CD. Our production has suffered loss for the said piracy, along with number of other film producers. A racket is involved in activities of piracy with Delight Cyber Cafe. Because of the aforesaid activities, the institution of the informant has been deceived and suffered losses. Therefore, I pray to your good self to punish the guilty person by taking legal action. It is the informant who seizes all the articles, the VCDs, the computer copiers and everything. Thereafter, the police arrives now. May I take your lordship, the PWs, my lord?
Hmm.
6 PWs, my lord?
Yes.
PW1 at page 21, my lord, who is the brother of the accused.
PW 1, 3, 4, and 5 seizure witness.
W
1, 3, 4, and 5. Who is informant? 6 is IO.
21. The accused person in this case is my brother. I know the informant. In connection with this, the police seized 3 computers from the shop of the accused and took my signature in the seizure list. But 3 computers, it's a cyber cafe, my lord. Obviously, there will be computers, my lord. That does not prove infringement of a copyright. On cross-examination, my lord, during the course of search, I was not inside the shop. I was not shown what goods were found. I did not read and see what was written in the seizure list. Police told me to have found 3 computers. This is PW1, my lord. PW2, who's the star witness, my lord, the informant, my lord, at page 23.
Yes.
I am the informant of this case. I know the accused that I am one of the owners of Messrs. Entry Productions, which produces musical and audio video cassettes. On 6/4/2005, we had published a musical cassette of musicians Jubin Garg, namely Ringa Ringa Mon. That immediately after the release of the said cassette, we came to know that the accused was illegally publishing and selling pirated versions of the said cassettes. On 8/4/2005 at about 3 p.m., we informed the Jorhat police station about the same and we proceeded to the shop premises of the accused, namely Delight Cyber Cafe, situated at Balibhat, Jorhat. That in the said shop premises, I found innumerable pirated cassettes of the said cassettes and computers used for making pirated cassettes. That we also went to the nearby house of the accused and found 3 copier machines. That while we were searching the house of the accused, the police arrived and checked all the copier machines, etc., and seized the same. That thereafter we showed the police some other original musical cassettes and pirated versions published by the accused. All these processes continued till 9 p.m. I could not file the FIR on the same day, and next day I file Exhibit 2 FIR of the case with the Jorhat police station. The Exhibit 2-1 is my signature, cross-examination. I have not submitted any separate document to the police to show that the copyright of Ringa Ringa Mon rests with us. It was mentioned in the original cassette itself. We have a certificate issued in the Copyright Act for publishing video cassettes. We need not apply for separate certificate for publication of each and every cassette. Therefore, we did not have any separate certificate of copyright for the cassettes Ringa Ringa Mon. It is not a fact that we have obtained separate copyright certificates for every musical cassette. It is not a fact that the copyright rights of the cassette allegedly pirated by the accused did not rest with us. I have not mentioned in the FIR who is the proprietor of Delight Cyber Cafe. It is not a fact that the accused is no way connected with Delight Cyber Cafe. It is not a fact that nothing was recovered from the possession or the house of the accused. It is not a fact that we did not possess any copyright of the Ringa Ringa Mon and the other cassettes. The accused cannot be held guilty for publishing pirated versions of the same. It's not a fact. I did not meet the accused on the day of the alleged seizure and find anything from his possession. Now, admittedly, my lord, no certificate to show that he was the owner of the copyright was ever exhibited or ever seized by the police. It was only on the oral statement made by the informant. PW3, page 25.
Yes,
my lord.
yes.
I know the informant and the accused person. The accused person has his house shop nearby my shop. On the date of occurrence, the police, having called me to the shop, took my signature on a blank paper. PW4, my lords. I know the accused person. The informant has initiated this case as a duplicate CD of Messrs. NK Production by name Ringa Ringa Mon was found in the shop of the accused. The police called the accused person from his house and seized the copier machine, CD writer, duplicate CD, blank CD, etc. from the shop of the accused. Thereafter, the police seized the shop of the accused. Cross police did not take my signature on the seizure list. I reached the shop of the accused person after the search was made by the police. It is not a fact that the police did not seize copier machine, blank CD or duplicate CD from the shop of the accused, and I have deposed falsely. It is not a fact that police did not seize CD of Ringa Ringa Mon. Now, my lords, a copier machine, my lords, it is available in all computers, my lords. A CD copier, my lords, even at the non-commercial establishments, my lords, we used to have CD copiers, my lords. PW5, my lords.
I've seen that. My reading is complete.
Otherwise, my lord, learned.
See, the foundation is
Yes.
not established that these CDs were
Yes.
recovered
Yes.
and these CDs are pirated, matter ends there.
There was no identification and
Nothing.
differentiation of the original,
Original
pirated
and the
copies.
copy. Nothing is there. Except somebody saying we went to that shop, there are many CDs and cases, this copiers meetings are given, this is the Caesar list. Even Caesar witnesses also not supported the case of the prosecution. Hard. Okay, we'll dictate this order today in the court itself after some time.
Well,
Let the short matters be over. That
at two, my lord.
orders at 2. At 2 will dictate this order.
Yes, yes. Some judgments may not be required. my lord.
You want to give some? Okay, give us.
Please, I'll read it. On the point that, my lord,
Just a minute. The point that
CD is a document as per now it's well established, but nonetheless. my lord.
give us.
Deeply obliged with it.
What is it? Master full pending it. Get him?
Sachin may kindly peruse earlier orders, my lord.
None appears.
None appears. And my lord, notice also not served to my, not taken steps, my lord, by the petitioner, my lord. 8523, no steps taken.
What is the matter about?
Sir, my lord, I have not gone through in detail, my lord.
448, 354.
Earlier, one order is there that name of Mr. K. Burwa is also, my lord, wrongly.
Wrongly shown.
Yes, my lord, that is the, in that regard, my lord, one order is.
Who is the counsel in fact for the petitioner?
The name of Mr. K. Burua, Mr. P. Bodule, and Mr. S. Sir in the college.
Refused.
Yes.
Uh, the notices issued to the respondent number 2 and 3 were returned being refused. There is a note to that effect in the registered envelope by both the by respondent number 2 and 3. In view of the aforesaid, let this matter be listed for admission column. Admission column, January.
Wait, please, Your Lordship. Appearing in item number 5.
This is can be disposed of.
Lordship, it's covered.
Isn't it? Cover case.
Yes.
Uh, everywhere that notice is challenged,
Lordship, the clarification dated.
dated the 2/3/2023.
Lordship.
Some of the petitions, they have specifically given the permission, which has been halted because of non-payment of this. But in some of the petitions, Lordship, that permission has not been specified, which permission they want to.
So maybe we will not say, we will not go to individual facts. We will say that basic grievance of the petitioners is a communication dated 2/3/2023, on the basis of which they are that the authorities are trying to impose a cess of 2%. What we call it?
Forest royalty.
Forest royalty of 2%
on the
for
private.
grant of building permissions, etc. Isn't it? And this issue has already been determined in this Amor Deka, isn't it? Amor Deka and
Jyotika
others.
Chaudhary, there is.
So that judgment will cover them, that's all.
Another,
Huh?
another aspect Lordship might consider, that leading matter 2040, that is filed by the real estate developers agency. So
So-
Lordship, will it?
You want to go on that, already matter is decided. Why you should futile exercise, why should we do? We are just saying that this matter is covered by the determination made in so and so, that's all. Nothing more. In fact, that order is also not required. Can you impose upon anybody? In fact, this matter has become infractious in view of determination made, that's all.
That can be.
When new person apply, my lord, they again demand forest ultimately.
That observation can be given,
Huh?
that,
Uh, The the present batch of writ petitions are taken up today for disposal in view of, in terms of the determination made by a coordinate bench in WPC 4085/2024 within bracket Amor Decca and another versus State of Assam and others. Full stop. By the present batch of writ petitions, no, the petitioners are aggrieved by demand of forest royalty, 2% forest royalty as a condition, 2% forest royalty by the municipal board / urban authorities for as a precondition for grant of building permissions, etc. In terms of communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam Mines and Minerals Department. That is Mines and Minerals Department. Full stop. Mines and Minerals Department. The aforesaid notification was also put under challenge in Amor Decca Supra. Full stop. While dealing with the aforesaid notification, this court observed, finally passed the following direction. Paragraph 19 and paragraph 20. Twenty-one, huh? 20, 19, 20, 21. Full stop. It is agree, full stop. This batch of writ petitions shall also be covered by the aforesaid determination made. Full stop. Yeah, determination in as much as this determination made in Amor Decca is a judgment in rem and cannot be said to be a judgment in personam. And shall be be applicable unless it shall be applicable in all similar cases. Full stop. With the aforesaid observation, the present writ petition stands disposed of in terms of paragraph 19, 20, and 21 of Amor Decca Supra.
Please, your lord.
Yes.
Lordship, my lord, I have gone through the record, my lord. The LCR for the Lanit trial court below not received, my lord.
LCR from Learned Trial Court below. Which case?
29 item number.
What is the case here? Why? What is criminal mission? Huh? LCR is there.
LCR of the appellate court, Lanit appellate court has been received, my lord.
Okay.
But the LCR of the Lanit trial court.
What is the challenge here?
My lord, conviction under 408, my lord.
408 for
6 months, my lord.
6 months. By the present writ petition,
Not rate petition.
sorry, by the present petition, the petitioner is aggrieved by judgment and order dated 2/5/2014, passed by Learned Additional Session Judge number 1, Kamrup Metro, Guwahati, in criminal appeal number 131/2012, whereby the judgment and order of conviction dated 2/11/2012 passed by Learned CJM Kamrup, Guwahati, in GR case number 2322/2009 was affirmed. Was affirmed. Full stop. It is seen that though this court has earlier called for the record and record of the appellate court has received, however, record of the trial court, that is record of GR case number 2322/2009 has not yet been received. Full stop. Registry shall verify and call the same from the appropriate court.
Obliged.
List this matter February. In the first week of February, on a date to be fixed by registry.
Deeply obliged, my lord.
Yes. You have select?
The CR case and the complaint itself, my lord.
What is the
Case 14, the vernacular.
page? 1/4. Yes.
Was filed, my lord, before the SDGM Hojai, my lord. Complainant is the Anwara Begum, my lord. The accused is, my lord, Kamrul Islam, my lord. Is under section 366 and 376, my lord. Date of occurrence, my lord, 24/5/2013.
24,
Legal, sir, my lord.
24,
24/5/2013.
2013.
Married, my lord. এদের অভিনয় বিনীত নিবেদন এই যে বা অকু তাৰিখ মছাৰিবৰ আজানৰ সময়ত কৈৰাদী কাষৰ ঘৰৰ পৰা আহি থকা অৱস্থাত এজনে তীব্ৰ বেগত বাইক লৈ আহি কাষত ৰাখি বলপূৰ্বক বাইকত উঠাই আৰু ডবকা মিকিৰগঞ্জ নি এটা ঘৰত ৰাখি মোৰ ইচ্ছাৰ বিৰুদ্ধে ধৰ্ষণ 2-3 বাৰ কৰে। পিছত ৰাতি অনুমান 10 বজাত পুনৰ বাইকত উঠাই এখন বন্ধ দোকানৰ কাষত ৰাখি বাইকৰ তেল ভৰাব বুলি কৈ গুচি যায়। কৈৰাদী হ'ব বুলি কয়। প্ৰায় 1 ঘণ্টা অপেক্ষাৰ পিছত কৈৰাদী 1 নং সাক্ষীৰ ঘৰত গৈ মাত দিয়াত তেওঁ ওলাই আহি সোধপোছ কৰি ভিডিবি সেক্ৰেটাৰীৰ মাতি দিয়ে আৰু মোৰ পিতৃক খবৰ দিয়ে। পিছত 1 নং সাক্ষী আৰু ভিডিবি সেক্ৰেটাৰীৰ আশ্ৰয়ৰ পৰা মোক উদ্ধাৰ কৰে।
Why should you cause this?
My lord, then my lord, yes, my lord.
Huh?
The statement of the victim was recorded in 164 statement, my lord, at page 18, my lord.
That I have seen that. Rape allegation remains.
But my lord, there is a love affair and promise of marriage, my lord. Can I read that, my lord?
Yes.
Page 18, my lord, 164 statement, my lord. কামৰুলে মোৰ ভাই হুছেইন আহমেদৰ সৈতে চিনাকি হৈ আমাৰ ঘৰত অহা যোৱা কৰিব লয়। আমাৰ ভাল পোৱা হয়। সি মোক লৈ যাব বিচাৰে। কয় বিয়া পাতিব। মই ৰাজি নহওঁ। কওঁ যে মা বাবাই দিলেহে যাম। অৱশেষত মই মান্তি হওঁ আৰু তাৰ সৈতে যাওঁ। মোক বাইকত সি লৈ যায়। সেই সময়ত ঘৰত কোনো নাছিল। ডবকাৰ মিকিৰ বস্তিত নি জংগলত সি মোক বলাৎকাৰ কৰে। বিয়া নেপাতিলে আৰু বাইকৰ তেল নাই বুলি এঠাইত বাইকৰ
When she was raped?
My lord, in the FIR complaint, my lord, it was said in a house, my lord.
Oh, don't say all this. In a house, in a forest. Can we determine that in a house? Is this a statement or not? Don't argue that. Don't argue factual aspect and contradictions. Put in the cross examinations. Now tell us, according to FIR, when the date of incident?
My lord, date of incident, my lord, 24/5/2013.
24/5/2013. FIR lodged when?
My lord, it was 29.
1/6/2013.
What?
No,
Tw- 29/5.
complaint file on
29/5/2013.
29.
And FIR was
And
registered.
proceeding is stayed. FIR is investigation is stayed.
And my lord, the complainant is 22 years.
Oh, that we understand. But there is a specific allegation of marriage. It is not that we had our consensual sex and subsequently he refused to marry me. This is not the case. Here specific case, and you raped her and left her at a place. Somebody recovered her, VDP. It is not a case that you are a major having a consensual relation, so subsequently he did not marry, so it is rape. This is not a case. Your specific allegation is that you had taken to a place, you raped, you raped her and left her there, saying that you did not have bike. Maybe consent, maybe you had a love affair, but she said it to be rape. And VDP statement we do not know. Why should we? What LCR? What LCR will come out? Investigation is stalled. You cannot straight away say that this is a case, at best a case of sitting not 376. And at this stage,
My lord, when it, my lord, because the consent was vitiated because there was a love affair, my lord.
that we understand. There was a love affair, but she has not said that that he promised to marry, therefore we had consent. She specifically says you raped her and left in a place. It's not a case that we had a long love relation, so we had consensual sex, or we had sex, thereafter he did not marry. This is not a case. Here specific allegation is that you took her to a place, raped her and left her there, did not marry.
$730, my lord.
Huh?
At
Oh, that we
7:30.
cannot decide. Police will file a final report.
Problem is, my lord, the bail has been rejected, my lord.
Huh?
Bail has been rejected, my lord. The
That's why you have come for quashing. Bail has also been rejected. Why is bail rejected?
From the contents of the FIR, my lord, this is not a fit case for.
This is not a fit case. Hard. Mr. Roy, learned counsel for the petitioner. Also, Mr. Thakur, learned additional public prosecutor. The present application is filed under Section 482 of the Code of Criminal Procedure 1973 for quashing Murachar Police Station case number 101/2013 corresponding to GR case number 727/2013 registered under section 366/376 IPC. The basic grievance leveled in the FIR is to the effect that the the accused and the complainant Doe had a relation. The accused took Doe had a love affair. The accused took her in her bike and raped her against her will in a house at Doboka. Thereafter, at about 10 p.m., he went away, saying that he went away, and after awaiting for about an hour, she called the local VDP secretary and informed her father, and she was recovered by the VDP secretary. VDP secretary. The statement of the victim was also recorded under section 164 CRPC. In her statement, in her statement recorded under section 164 CRPC, she reiterated that though they had a love affair, the accused took her to Mikir Basti and raped her in the forest and subsequently did not marry. Though Mr. Roy Learned Counsel has submitted that it is a case of consensual sex and affair has been lost only for not marrying. However, this court do not find any merit on such argument, more particularly in view of the facts, that both in the affair and 164 statement, though she admitted of having a love affair, but specifically alleged forceful, but specifically alleged rape by the accused and her accused. Full stop. In view of the, it is not a case that they are having it is not the case of the victim that the accused and the wife, accused and the victim, due to their love affair, were having consensual sexual relation. However, subsequently, the accused did not marry and therefore the affair was lost. Rather, it is specifically alleged that on 24/5/2013, she was raped by the accused. The fact also remains that after perusal of the case diary, this court earlier rejected bail, anticipatory bail to the petitioner twice. In the considered opinion of this court. Yes, what is it? Bail, anticipatory bail to the petitioner. Yes, why you have entered? What is your item number? Yes, what are you doing? How can they enter? Who has given them permission right now? They may seek permission, but this is not their case right now. That what is their item?
35.
Person. After perusal of the case diary. Full stop. After perusal of the case diary. Twice after perusal of the case diary. Full stop. Therefore, in the totality of the matter, this court is not inclined to watch the FIR, more particularly when prima facie case is disclosed. Again, the prima facie offense of section 376 is disclosed in the case. And this court would not like to stall the investigation. Full stop. However, while parting with the record, it is made clear that investigating authority shall be at liberty to investigate on their own and shall not be influenced by any of the observation made in this case. Interim order or passed earlier stands vacated. LCR be returned back. LCR be returned back. Yes, Mr. Bhuya. Negotiable Instrument Act 138 was dismissed or default.
Yeah.
Then it was restored by the magistrate. And that was fixed for evidence. Against that, this petition is filed saying that magistrate is having no power to review its earlier.
There is a subsequent judgment. Initially, it will be a case of, if it's a case of discharge, then it would be revision. Otherwise, acquittal, then appeal against acquittal. But there is a subsequent judgment of the Supreme Court, which I have come across, I don't remember right now, where it says if it is dismissed for default, not on merit, the court on sufficient reasons can restore it. My lord. There is a Supreme Court judgment. One line has been there, my lord.
This court has also says that I have gone through the decree of Supreme Apex Court, which was similar nature, default as for that which case whereby Honorable Apex Court was pleased to hold this one regular default of the complainant is liable to be condoned and a valid ground for restoration of the complainant. Here only one date it was not present, and then not present, then it was immediately it was filed by the lawyer saying that on that court was suspended, so they thought that they will take the take steps.
This appears to be item number 30, criminal petition. My lord has all the powers.
There is no as such order that he is acquitted or discharged. It says, I propose that on the last date also the complaint was absent without steps. Hence, I propose that the complaint has lost. Suppose that the complainant has lost the interest of the case, therefore the complaint is dismissed. Or what to do
And
petitioner?
that will be dismissal because evidence it was fake. So it will be acquittal, my lord.
Ah. But what to do?
If your lordship allows me, my lord, oh, he has come, my lord.
Yes, you are for?
I'm for the petitioner, my lord, in this.
Yes.
My lord, basically by this petition, I am challenging an order passed by the learned trial court. My lord. My lord, may directly come to page 19. My lord, basically the respondent, which is a hardcore, they have lodged a complaint against the accused person. Now, my lord, may kindly come to page 19. There, the order is passed by the learned trial court. I am reading it. Parties are absent without stay.
No, we have already completed our reading. Please argue on merit.
My lord, otherwise it is a fit case to dismiss this particular complaint, my lord. Because it is not a disorder which I am challenging, because this order is in my favor, but I am challenging the subsequent order that my lord
That
will
is
find
restored.
at page 23.
Ah.
At page 23, my lord may kindly come to page 24.
Hmm.
Initially, what has happened, my lord, on that particular.
I'll tell you what is happened. It is not here. Their case is that it was dismissed for default. They
Yes,
filed an application saying that there was court suspension. So we thought that we'll take the date later on, but it was dismissed. Then they file an application
application.
for
my lord.
restoration. The magistrate says that, see, look at this. Once they have defaulted, taking on note of some Supreme Court judgment, let it be restored.
Let
It was
be
restored.
My lord, that power is not vested to the. My lord, if a particular case has been dismissed, then it is implied that the accused person has.
Now, what is the
defeated.
present status?
My lord, the case is pending like that because the honorable, this honorable High Court.
Where is the
granted
other
stay.
side? Notice served?
Notice has been served, my lord. Their name has also been reflected in the cause list.
Who's name?
Some N. Borua, U. Sharma. The trial courts, so far as the criminal trial courts are concerned, they do not have a power to review their own order. This is a very simple case.
Okay, they don't have a review. We'll exercise a power under 482. We'll say that he has no power, but in the given facts,
This 482
on
petition has been filed
138.
by me, my lord.
Huh? Yes, you have filed it. So
Yes,
we'll dismiss on the ground that though they have not done it, we'll approve it in proper manner. We'll not say
Then
decision
a
patent
particular-
cannot be said to be it will be otherwise it will be a miscarriage of justice. If we don't exercise our power, it will be a miscarriage of justice. What do you say?
My lord,
482.
miscarriage of justice is another thing, my lord.
No,
Now,
that
the
is
first,
one
my
of
lord,
the
court has to
vital
ascertain
power.
Whether is there any illegality that has been committed by the
No, no,
trial
this
court?
is not only. Illegality and miscarriage, justice is done. That justice, we have to see that justice is done.
Then,
Isn't it?
if my lord so moto exercise the power of 482, then I will be deprived, my lord.
So
Because
therefore,
learned trial court
I am
already
giving,
committed an error.
therefore I am asking you to argue.
Argue.
Therefore, if you want some time, you can take time. No problem on
My
that.
lord, some time may be granted only for today, my lord.
Okay, I'm giving you some time. You argue it that no, this is not a case where we should not exercise, and this is not a miscarriage of justice.
Lord can exercise his power under section 482, but so far as
This
the
is not a fit
exercising
case.
power so moto, this is something different, my lord.
Tell us why we cannot.
Error that has been committed by the trial court, it
Uh.
is duty of the higher superior court to correct that error and give the appropriate relief to the party who has appeared before this honorable court and saw. My lord, may kindly grant some time for today, my lord. Next day I will convince my lord.
Yes, yes, I'm open.
Deeply
I'm
obliged.
open because they are also not here.
Deeply obliged.
Yes, we'll have to balance
Yes,
everything in this
then I
power.
totally agree. There is
We'll
no
have to
dialogue.
balance. Reopening. Which year? 2014.
14.
Before vacation, will
My
you
lord, it will be
after vacation?
After vacation, immediately after vacation.
Yes.
Immediately after vacation. 7, 25.
7
Deeply obliged, my lord. On that day I will come.
Yes, Mr. Bhuya, I think now you have got the correct order.
Yes. Yes. Thank you, my lord. I'm deeply obliged, my lord.
Sometimes
It happens, my lord. My lord, this has been a quashing petition of 2014. Now I have come for quashing of the affair as well as in the charge sheet, my lord. Your lordship goes to the affair, that is at page 8, my lord.
Mm.
This is with regard to some docaity being committed by many a persons, my lord. Valuable has been taken away. Affair is dated 12/1/94, my lord.
12/1/94.
Yes, 12/1/94 affair, my lord. Nobody has been named as per the affair, my lord, and the 164, my lord. These were covered with mask and all. Page 12, my lord, is the charge sheet, my lord. That is dated 11/9/94, my lord, wherein my name appears as Robindra Bosumatore, serial number 5. And my lord, perusal of the affair itself shows that there was no TIP also, even if I was arrested. My lord will kindly come to, my lord, page 17, annexure 3, wherein statement of 161 statement of 5 witnesses were examined, my lord. I don't know if there is more in the record, my lord, but my client could gather these 5 statements of the complainant, who is the informant, PW1. I could not recognize the boys. There is a line in between, my lord.
I have
Yes.
marked it.
Yes, and PW2, 3, 4, and 5, my lord, none have ever, my lord, mentioned my name. Now, after charge sheet, my lord, never summon has been served. This with regard to declaring a person as an absconder, it's never been followed. He never knew about this pending of this case. The case against him was split up, and in the meantime, my lord, he was to stay in the relief camp because his house was also burned. But whatever it is, during the trial, my lord, after split up, my lord, at page 20, one PW has been examined, my lord, and he is the informant of
What
this
is the
case.
present status?
Present status is been stayed against this particular accused person.
But whatever happened to the trial?
Trial, my lord, with regard to this person acquitted, my lord, these 5 persons were tried, they were acquitted on the basis of this, my lord, page 20 evidence. Page 20, my lord. PW1 has
So
been
you want to say others were acquitted? Where is that?
others, my lord, there
Where are the
many a person's name is an accused person, 9 person, my lord. 5 were tried, my lord. It appears from the judgment, my lord.
5 were tried.
Yes.
Let us see on basis of what evidence they were ultimately.
One witness only. This PW1.
No other witnesses are examined.
Been examined because one of the, my lord, it's been recorded here, my lord. Kindly see at page 22 is the copy of the judgment. This is with regard to this, my lord. And 6 others. Charge sheet were 6 others. So 5 were tried, my lord. 395, my lord. This point of determinations, my lord. Charge were framed under 395, 397. And at page 24, my lord, will kindly come to PW1 deposit. He's the informant. At the time of this, he did not identify the accused person as they covered their face with black cloth. Now, these are the things that has been stolen. Now, paragraph 7 is very important. Instantly, informant alleged that on the date of occurrence, 30 persons committed docaity in the house, so and so, so and so. But in his affair, he has not mentioned the name of the
Mr. ABL learned counsel for the petition. What will happen? That is the witness. That is his statement in the FIR also same 161.
All are acquitted.
All are
The
acquitted.
problem is only that, my lord, this accused person has never faced the trial.
Never faced.
Never face.
I have given
We
the
will not
160.
allow him to face at this stage now.
I'm deeply obliged.
Mr. Learned counsel for the petition. The present application under section 482 of the Code of Criminal Procedure 1973 is filed for quashing the prosecution which arises out of Dhaligaon Police Station case number 5/94 under section 395/397 IPC. Full stop. An FIR was lodged by one Milon De son of Ramanath Dev, inter alia alleging that on on 11/1/1994 at about 1:30 a.m. about 30 persons entered into his house and fled away after taking all his belongings. It was further alleged that they attacked the father of the informant by using weapons and fled away when the when the father of the informant got injured and fell down. Full stop. After completion of investigation, as many as how many?
The charge sheet, my lord, page 12, my lord. Arrested accused 11, my lord.
11 persons. 11 persons were sent for trial, including the present petitioner, namely
Robindra Bosumotari.
Robindra Bosumotari. Robindra Bosumotari. First up, it is the contention of the petitioner that the petitioner did not receive any summons or warrants from the learned trial court below, and therefore he did not appear in the trial, though he was sent to face the trial. Full stop. Full stop. During the course of investigation, the investigating officer also took a recorded statement under section 161 of the informant and as many as 5 persons. Full stop. The informant in his 161 statement specifically stated that he could not recognize the culprits and he do not know the name of persons who have committed the offense. None of the other witnesses whose statements were recorded under section 161 CRPC also identified this any of the accused offender. Be that as it may, when the petitioner did not appear in the trial, the other accused persons, how many?
5, my lord. 5 with 5.
Other accused persons, that is 5 accused persons were tried, and the learned trial court, on the basis of relying on the statement of the PW1, that is informant, acquitted all the accused person who faced the trial. Full stop. It is on record that the PW1 in his deposition that PW1 during the trial testified that at the time of incident he could not identify the accused persons as they were covered with their face with black cloths. And he further deposed that he failed to recognize them. The learned trial court had made its conclusion in the following manner. There is no pagination.
24.
Huh? There is no pagination. Huh? You see this. Paragraph 7. Huh? From the aforesaid, it is also seen that the PW1 informant informant testified that he could not recognize any of the accused person. Full stop. Therefore, in the totality of the matter, this court is of the view that there is no material to prosecute the accused person, even if the 161 statement as well as the FIR is accepted to be correct at its face value. Accordingly, stands closed.
Deeply obliged. Deeply obliged.
Criminal petition allowed. First. So far, some relates to the present petition. None appears for the petitioner on call. The present application is filed. Yes, give a notice. RC Shakya will take action against the lawyers. Give a notice in the circular. If nobody comes, we'll take action.
Mid-page lordship.
Yes, what are you doing?
Lordship, when I entered in it was directly unmuted. I tried it to mute it, but I was
You
unable.
should not so early. You should enter into the while court is doing
So
so.
there was a problem in the network.
Yes, tell us.
Will find the FIR at page translated copy at page 14. Lordship.
Yes,
Lordship, kindly take up 806 first. Criminal petition 806.
80.
6. To petition for passing of the FIR in charge.
Where is the FIR?
Lordship at page 14. 1-4.
Page 11.
1-4, 14. Lordship.
Page 1 4.
14 is the translated copy.
And what is the second FIR?
Can FIR you will find petition 807.
What is that?
Similar, the story in the second FIR is prior to the first FIR. It has been logged. FIR at page 14 only.
Registered under?
Second FIR was registered under section 31500. I was lodged under section 417, 366, 109, 506, and 34. Subsequently, the charge sheet was filed under section 366, 377, 76, and 506. Lordship.
We have fixed
Kindly
all this
also look
matter
into the
for
164 statements of the
Huh?
comment. 164 statements of the 164 statements of the comment. 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 164 sta
Yes, Bhattakur, yes, who are you?
For a private respondent, I
Yes.
filed one affidavit in both the cases. Regarding the merit of the case, I only want, yes, there was a law.
Now, what is the
Now,
present
sir,
status?
I got married to someone else, Lordship. I am
You
living my
also
life.
got married to someone else. Hard. Come on, order. These two, it is hard, Mr. Swenshaw. You are Mr. Jain Agarwal. And
I'm B. Bora, Lordship.
B. Bora for the informant victim. And Mr. Bhattakur, Learned Additional Republic. These two petitions are taken up together for final disposal. Having no, sir. So, in criminal petition number 806 of 2014, an FIR dated 7/2/2014 registered as Dergaon PS case number 73/2014 under section 376/313/500 IPC is under challenge. In WPC 80 criminal petition 807/2014, the challenge is made to the FIR registered as Dergaon PS case number 18/2014 under section 417/366/109/506/34 IPC. Dergaon PS case number 18 of 2014 was lodged on 8/7/8/1/2014 by the respondent number 2 against the petitioner, inter alia alleging that on 6/11/2014, how can be 14? 7
6th of January. There's a mistake. 6th of January.
6/1/2014. On 6/1/2014, at about 5 p.m., the victim was kidnapped by the accused on the instigation of one Asia Khatun, and she was kept confined. In the affair, the victim further alleged that the accused person cheated her by giving false inducement and inducement, and the accused Taslim, accused petitioner gave her inducement of marriage and otherwise threatened to kill her. In the FIR registered as Dergaon PS case number, the Dergaon PS case number 73 of 2014 was lodged on 7/2/2014. Is that it?
7/1/2014.
7, no, Dergaon 73. Earlier was 18.
Yes, sir.
73 was in February.
February 25th, Lordship.
26 to
25th of February, Lordship.
25th of February 2020, 2014. In the said affair, it is alleged that the accused and petitioner and the victim has been in a romantic relationship since last 4 years, and the accused gave her inducement to marry and establish physical relationship. Subsequently, she conceived. However, the pregnancy was aborted by the accused petitioner by giving medicine. Full stop. During the in the proceeding, the informant has filed an affidavit. Stating that though she do not wish to deny the allegation she had brought against the accused petitioner, according to her, she had never alleged any rape against the accused petitioner. It is also specifically stated that the victim wants to start her fresh life. Fresh life, and do not want to continue with the prosecution launched against the accused petitioner. It is stated by the learned counsel for the respondent victim that she had already got married and having her happy married life, in as much as the accused has also in the meantime married and he is having his happy married life. Be that as it be, in the totality of the matter and perusal of the FIR, both the FIR, what is discernible is that the accused and the petitioner had a romantic relationship, and their relationship was broken, and at that point of time the affair was lost. Therefore, in the totality of the matter, no case in fact registered under 376.
It was registered.
No case under section 376 or section 366 is made out from the bare perusal of the affair. Be that as it may, as the parties has agreed not to prosecute itself, though the allegation is heinous in nature, however, considering the matter in totality, no fruitful purpose will be served if the accused petitioner is allowed to face the prosecution, more particularly when the victim had filed an affidavit before this court clearly stating that she is not interested to pursue this matter, and there was admittedly a relation between them, and she want to lead a happy life. The present petition stands allowed. FIR set aside, quashed both the petitions allowed. FIR dated so-and-so, Dergaon PS case number so-and-so, and Dergaon PS case number so-and-so stands quashed.
Obliged.
How many matters are there? Yes, sir. Huh? Yes, Munir, what is the next matter? What is this case?
498A, my lord.
And
Now the
This case,
it has been they are divorced, my lord.
the respondent is here?
Was here, my lord.
Okay, we'll close it.
otherwise in
498.
this case, my lord, sheet submitted from the record, it reflects that, my lord.
Maybe.
Yes.
Maybe the judgment you bring it to that even if during pendency charge sheet is filed, you can interfere.
Yes.
Recent judgment is just approved. And what about item 40? After some time, whenever you free. Okay, at 2, we have also some other outline. Yes, Mr. Sheikh, which is your item? Yes, what is this? Yeah.
Lordship, I'm appearing for the petitioner. As per the instruction of my petitioner, he has instructed me to withdraw the petition as he doesn't want to continue with the matter.
Learned counsel for the petitioner,
A. Bora.
A. Bora, submits that the petitioner is not interested to pursue item 40, pursue the present criminal petition, and accordingly, she has instruction to withdraw the present petition. First up, Mr. Sheikh, learned counsel for the respondent, has not objected to such prayer. Accordingly, the criminal petition stands closed on withdrawal. Interim order, if any, stands vacated. In view of the order passed in the criminal petition, IS stands closed. Yes. Rest will come back at 2. See. And I'll go through your judgments also. Almost decision is, mind is clear, but still I'll just. Yes. Yes, Nikita. What is this review? Where is the petitioner?
Demand for the respondent.
You are for a respondent. What kind of review are they seeking?
Your Lordship, on course petitioner, the leading counsel is having some difficulties.
Okay,
So-
no problem.
Okay.
What they want, Madam Nikita? What review they want? Which part?
They want a review of the order citing section 14 of the Zoom Land Regulation Act, saying that this has been ignored, but it was never placed before the single bench.
Okay, on the prayer review, petitioner has prayed for an adjournment. Prayer stands allowed. List this matter after January.
My lord, can it be? We are waiting for the competition. Can it be on Tuesday?
Tuesday.
Yes, this coming Tuesday.
Okay. Up to her.
17. I've spoken to her. I mean, since her senior requested me, I've
Okay, on 17th.
17 now.
Okay, on 17th. Yes.
Obliged.
How many matters are left?
May I
Yes.
please, your lordship? Lordship, Argument Council PK Munir is on lakes, my lord, at court number 10.
What is the issue here? Just short.
My lord, only my lord, wife filed a FIR, my lodged an FIR, my lord, under section that has been registered under section 498A.
Then?
That FIR is sought to be quashed, my lord.
Now, what is the present status?
Present status, my lord, respondent wife, she has got married with another boy, my lord. He is, my lord, marital status in other family, my lord. And now, my lord, she is not interested. Only, my lord, interested to continue the case. Now, my lord, she, as per her instruction, my lord, the marriage solemnized with Maharana at rupees 1,01,001 rupees. My lord, this part, my lord, she is object, my lord. This part her right to get this money, my lord.
You are happily married with somebody else, you want money from him.
Whatever instruction, my lord, I am placing before you lordship, my lord. Otherwise, my lord, he is not interested, my lord. My lord, your lordship close this matter, my lord.
Where is the question of Maharana under 498? There is a separate procedure.
Separate process, my lord.
You are at liberty.
My lord, that part may be clear.
If you are still interested to harass your ex-husband,
No, my lord, that is not my, as per my.
don't do this. Don't advise all this. Where is the FIR?
FIR page.
Case?
14, my lord.
FIR or complaint?
FIR, my lord. It was lodged before Varolomukh police station.
Who is your senior?
PK Munir.
Third, Mr. P.K. Munir, learned counsel for the petitioner. Also, Mr. Swencho, learned counsel for the respondent number 2. And who is for the public prosecutor? Okay, we'll record some Mr. Bothakur. The present application is filed under section 482 of the Code of Criminal Procedure 1973, read with repository for quashing FIR registered as Porolumuk Police Station case number 207/2017 under section 498A IPC. Full stop. The respondent wife lodged an FIR before the officer in charge Porolumuk Police Station on 19/4/2017, inter alia alleging that the accused petitioner married the respondent number 2 on 12/12/2013.
Yes.
And she lodged an FIR before Porolumuk Police Station on 10/4/2017 when her husband went missing from 7/4/2017 along with her gold ornaments and bank documents. Thereafter, the husband sent a talaknama from Mongoloi Sodor Kazi by post. According to her, in the said talaknama, the signature of the husband was forged, inasmuch as her name was incorrectly written. It was further alleged that her husband took a sum of rupees 1,50,000 in the name of furniture from his elder brother and brother-in-law, and also met it with physical and mental torture, asking for cash. And it is also alleged that on the date when her husband went missing, that is on 7/4/2017, elder brother of her husband asked her not to contact her husband, and it was also informed her that she could stay with her husband if she bring 5 lakhs from her residence. Also, on the basis of the aforesaid allegation, FIR Porolumuk Police Station case number 207/17 under section 498A was registered. Full stop. The petitioner approached this court for petitioner was granted anticipatory bail by this court in AB number 339/2007 on 29/4/2017. 2017, huh? Both 2007. This court or key court silo? No, by the learned session judge Kamrup. The learned counsel for the respondent submits that the respondent wife had in the meantime got married after the talak with the petitioner to another person, got married to another person after talak pronounced by the present petitioner, and she is not interested in pursuing the petition under 498A. However, she is still inclined to claim for her mohrana or meher, what it called, MEHR. Huh?
MAHAR.
Huh?
Mohar.
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 MOHAR. Mohar in terms of her Islamic right. Be that as it may, in the aforesaid backdrop, when the victim is not interested in pursuing the case registered under 498A IPC, 498 IPC, inasmuch as considering the nature of allegation leveled in the FIR, this court is of the view that further prosecution of the petitioner in Vorolumuk PX case number so and so shall lead to a miscarriage of justice and shall be an abuse of process of court. Accordingly, same stance set aside and passed. However, it is made clear that this order shall not preclude the petitioner, but the respondent wife to claim her right, if any, against her husband under her personal law. None represented the petitioner on call. No, when the matter was called in the first of pre-lunch session, not first, the pre-lunch session, none appears, and accordingly, none appeared for the petitioner on call. Accordingly, matter was called again in the post-last session. This time also none appears for the petitioner on call. In the interest of justice, matter stands adjourned and be listed in the third week of January 2025. Yes.
Lord, this is an appeal prepared against the judgment and orders passed by the special judge under the Prevention of Corruption Act. It is on earlier occasion, my first ground of challenge in this case, my lord, was section 17 of the PC Act, my lord.
Section 17 of the PC Act not followed or what?
Not followed. There is some procedure mandatory here, mandatory in nature. Those procedures are not followed in this case.
What are these procedures?
That is first section 7 proviso, second proviso to the section 17.
Section
17, my lord. There is persons authorized to investigate. Married, my lord. Notwithstanding anything contained in the Code of Criminal Procedure, no police officer below the rank A in the case of Delhi Police, Delhi Special Police Establishment of an office inspector of police. Now B may be
where section 17 proviso, second proviso, provided that if a police officer not below the rank of an inspector of police is authorized by the state in this behalf by general special order, he may. Which provision you are relying?
Next to that, my lord.
Provided further that all offense
referred to in clause E of subsection 1 of section 13 shall not be investigated without the order of a police officer not below the rank of a superintendent of police. That means any investigation carried out under section 13(1)(e), it is required that an order must be passed by a superintendent of police authorizing the IO to investigate the offense matter.
Okay.
That is it. So that in this case, there is no such authority has been given by the SP to the investigating authority. And inspector, the I was in the level of inspector, my lord. The name of the IO, my lord.
PW?
PW 6, my lord.
6. No order of superior officer.
Yes, my lord.
My lord, before he continues, I just want to like to point out, my lord, I have got one notification dated 28/6/91, my lord, from Google. Bhait government notification dated 28/6/91. Officers under Director General of Vigilance and Anti-Corruption Assam, not below the rank of Inspector of Police, were authorized to investigate an offence punishable under the Prevention of Corruption Act 1988. But my lord, I could not, my lord, get the.
You
copy-
obtain that because we can take
uh,
judicial notice of
yes,
that
yes,
matter. We obtain that. We will not
From-
conclude today. Let us,
From Google, my lord, I tried to find out.
you find, I think you will find it out.
Yes, ma'am.
If you ask the home department, they will definitely.
Notification dated 28/6/1991.
Notification dated
28/6/1991,
authorizing
authorizing,
not less than
yes, Inspector of Police were authorized to investigate an offence punishable under the PC Act 1980.
okay. Yes,
That thing what Learned PP is submitting, that is covered by section 17(1), my lord. That is separate, but that section says not below the rank of Deputy Superintendent of Police. I'm reading the section 17 again, my lord.
yes.
Notwithstanding anything contained in the Code of Criminal Procedure, no police officer below the rank, here C is applicable, my lord.
C.
Elsewhere, of a Deputy Superintendent of Police or police officer of equivalent rank. Means any officer equivalent to the rank of Deputy Superintendent of Police can investigate the offence. And now here Proviso 1. Proviso 1 provides that provided that if the police or officer not below the rank of Inspector of Police is authorized by the state government in this behalf by general or special order, he may also investigate any such
So
offence.
generally it is to be done by the Deputy Superintendent of Police.
Yes, my lord.
So with a state government empowering an inspector to carry out the investigation. So therefore they have a notification to carry out investigation by inspector.
Inspector, my lord.
Your case is that provided further that
Yes.
13(1) shall not be investigated without order of a police officer not below the rank of Superintendent of Police.
Yes, my lord. Yes.
You say that inspector can do, no problem
no
on that. Your case is that there is no authorization from the Superintendent
Yes.
of Police. This is your
Yes,
case.
that is my case.
But he's saying, Mr. Bothakur, is that
Yes.
generally it is to be by DSP.
Yes.
But state is empowered to investigate by an inspector by a special order.
But I would like to again point out, my lord, by such public officer in discharge of his official functions or duties. My lord, first you will have to, my lord, now whether did the, my
No,
lord,
no, what he's saying that
yes.
according to,
Yes.
we'll consider it.
Yes, yes.
What I think, please clarify it. What he's saying that yes, that inspector is having authority
Authority.
by virtue of that notice.
Notification.
But to exercise this authority, he needs further direction, authorization from the Superintendent of
Yes,
Police.
my lord.
One part is generally it is to be DSP, but DSP can be replaced by inspector. Second condition is when it is by a general power and inspector is replaced by a DSP, but that inspector is to be asked by the superintendent. This is your case?
That is
Okay.
my case.
Just take note of it.
And that law is
He's saying when an inspector investigates, he must fulfill two conditions. First, there must be an authorization, general or special. And second, as superintendent is to ask him that yes, now you can carry out. You have the authority.
that
This is his case.
that is-
Okay. Two conditions are required according.
Yes.
Yes.
One is fulfilled by them.
By that notification. Huh.
But another they have not fulfilled.
No, okay.
They have not produced.
Any cross examination from your behalf?
Not at all.
No,
my lord.
there is no cross examination. But in that regard, also the
Yes.
law is settled by the Honorable Supreme Court. My lord.
No, just this is my question. So you said that no cross
No
examination.
cross examination.
Even not any, nor any explanation, my lord, where from that disproportionate regarding that.
No, we will come to that point later. So no cross examination on this point. But what is your case? One by one, but what the Supreme Court says here?
The Supreme Court says that section 17 of the PC Act is mandatory in nature, my lord. Not only the written authorization letter is to be handed over, but also that is to be produced before the Honorable Trial Court, my lord.
That I have duly
I
authorized.
have the authority.
Where is the judgment?
Two judgments are there, my lord. One is the landmark judgment of Bhajanlal, my lord. That is
Paragraph? Bhajanlal paragraph?
1992 citation, my lord.
Citation?
1992 supplementary 1.
Supplementary one,
SCC 335, my lord.
SCC
335.
335. Which paragraph?
117, my lord, firstly.
117.
May I read, my lord? 117?
Not necessary. We'll go. We'll go. Just I want to understand your arguments. And what is the other case?
In Bhajan also 129 is also there, my lord.
129. And what is the other case?
At 131.
131.
131.
And what is the other case?
That one is, my lord.
We'll just have an overview today.
Yes.
You also, Bothagot, so that you
Yes.
can also prepare, respond to his argument. Just take note of what is argument.
Second one in my 2006, 7 SCC.
2006,
7 SCC.
7 SCC,
172.
172. Page,
Paragraph.
paragraph
13,
Hmm.
16, 18, and 19.
13, 16, 18, and 19. Bothagot, take note of it.
Yes. Ma'am.
Okay, so this is your first argument that entire investigation was by an authority who is not authorized under law. Therefore, entire investigation VCH.
Okay.
And therefore, trial will fail. And this is therefore, you could not have been convicted. And trial court has also not
Taken care of
has not gone into that aspect of the matter. Okay, then what is your next?
Next is section 19, my lord.
Section 19. What it says?
Section 19, a previous sanction from the government is required.
Huh?
That is also not done in this case, my lord.
Sanction is not there. Okay.
In that case also, my lord, I'd like to point out, my lord, that person was after retirement of that of the concerned, my lord, accused person, the charge sheet filed. My lord. So
Okay,
after,
so not necessary.
not necessary.
Okay, so section 19, no sanction. Reply is after retirement.
He retired from service on
Retirement.
31/1/23. Oh, 31/1/2003.
Charge sheet filed. Retired on
31/1/2003.
31/1/2003. Charge sheet filed.
Charge sheet filed on, my lord, 18/12/23.
18/12/2003.
2003.
Okay. Charge sheet filed on 18/12 and he retired on 31st of January.
Yes, ma'am.
First of the year and last of the month. Yes. Okay. And what is your next?
My reply to that,
Yes.
my lord, that sanction is not required after retirement. This law is applicable in case of offense under IPC and these general law.
Not under special law.
Not under the special law.
Okay. Any judgments on that?
No, I will.
You just found. Just take note. That's why we are arguing, because this matter is having some importance bearing, because you have issue raised some question of law. Then
my lord, the question of this trial comes, my lord. The prosecution has adduced the evidence of 6 witnesses, my lord. Out of them all, out of these 5 are from the department itself.
Then
one ground is with regard to the check period, my lord.
What do you say about check period?
Check period, my lord. The charge was framed, my lord. I'm reading the charge, my lord. That during the entire service period, since August 1986, he joined the service in 1986, my lord, to 31/1/2003, till the date of retirement, being a public servant as a forest ranger of Dalamara Forest Range, Karbi Anglong district, Assam, acquired disproportionate asset to the tune of rupees 8,36,985. Means charge was that since 1986.
From date of joining till retirement, this is this.
Yes. But the investigation, not investigation, there was a regular inquiry before the investigation. In that inquiry was caused from 1968 to 1993 only, my lord.
1968, 86. Not 68, 86.
It is wrongly written as 86, but it was actually
86,
68.
86. Huh?
It was actually 68.
How can be 68?
It joined in the year 68, my lord.
68 to 2003. 68 to
But
2003.
here during entire service period since August 1986.
No, it should be 68.
68.
68.
So charge was framed from the date of joining till retirement. But investigation was carried out from the date of joining till 1993.
Okay. In charge was framed investigation, regular inquiry.
Regular inquiry.
Inquiry with effect from
August 1968
August 1968
to
to
December 1993.
December 1993.
That apart, one property was found in the name of my wife, my lord. That property was constructed by taking loan from LIC.
So any wife's property by taking loan.
Nothing was found in my name, my lord. No property, no movable asset, nothing was found in my name. So that property which was standing in the name of my wife was constructed in the year 1983. But the same was evaluated with the price of 96 and 97 by the PWD department.
1996
and 97.
So according to you, valuation was wrong.
And apart
from that,
if your lordship goes through the deposition of PW6 IO.
PW6
Yes, madam.
IO, na?
Yes, IO.
Which witnesses you will specifically rely on?
It is IO, PW6.
According to him, what is wrong in his deposition?
May I read the cross part once, my lord?
Yes.
Cross of PW6, my lord. I had submitted the charge sheet after making scrutiny of the relevant documents which were seized during the course of regular inquiry. I had re-seized the documents which were seized by the inquiry officer. I did not collect and seize any other documents after registration of the case in connection with the case. My lord, meaning there he has done nothing in the name of investigation. Whatever documents seized, whatever inquiry made by
during that regular inquiry,
he has re-seized those documents from the therefore, my lord, I did not collect the salary statement of the accused. In fact, he did not collect my salary statement, my lord. The wife of the accused was also serving as LP school teacher. I did not collect the salary statement of the wife of the accused. So, thereafter, I had prepared the calculation statement on the basis of the income statement, White Exhibit 2. I did not consider the house rent received by the accused rupees 2,23,200. The accused was receiving a rent of rupees 2,23,200. That was not considered in my.
What was the amount of disproportionate asset?
8,36,980.
Okay.
If we deduct this amount from that, it would come to around 6 lakh something, my lord. So thereafter, my lord, and it only as reflected in Exhibit 2, during investigation, it was found that the accused did not invest any amount during the check period. I found no immovable property in the name of the accused. I did not investigate about members of the family of the accused. Now, next is important. I have deducted 35% of the joint salary of the accused and his wife towards family maintenance. Means he has deducted 35% from the income of the husband as well as 35% from the income of the wife. That cannot be done. Means, my lord, my expenditure became double.
Listen, your case is that you have shown my expenditure 35% of both. That becomes my expenditure. Yes.
The building which was evaluated in the name of Mufiza Hussain, wife of a thief, accused was constructed by taking housing loan from LIC by the wife of the accused. I did not examine any official from the PWD department regarding evaluation of the building. The inquiry report was submitted on 6/10/2001 and the case was registered on 18/12/2003 and the charge sheet was submitted on 8/2/2006. I did not examine the accused and his wife during the investigation. In fact, the accused and his wife are not examined by the IWADA.
I will go through the record and case there.
Yes.
This is basically my.
Can you prepare a note of your argument?
Yes, my lord.
Small note that I have not recorded it down.
Yes, my lord.
But if you can prepare a note again, I will go through this.
Yes, yes, my lord.
This material needs some application of mind, Bota. You also
Yes.
take note of what he has almost concluded his argument. So therefore, according to him, if these are the your check period, the way you have conducted, so you cannot straight away come to this conclusion that this is 8 lakhs. So therefore, he is entitled for an equity. This is your case.
Yes, my lord.
Okay, hard. Connect counsel for the parties at some length. When after vacation?
Yes, ma'am.
Is this matter for further hearing? Give a date motion. 9th of January. Motion. Huh? After Bihu, it cannot be
On
part.
19th.
We'll see. Motion. No, before 9th you keep it. We'll see. We'll see. What are the other methods? Yes, Sakya.
By this petition, the challenge has been made to the order dated judgment and order 12/8/2010 passed by the appellate court convicting the petitioner under section 3A of the Railway Protection Unlawful Code. There is no evidence against the petitioner for convicting under section 3.
Excellent. What the section 3 said? Railway.
3. It says, my lord, penalty for unlawful possession of railway property. Particularly, section A provides, my lord, for the first offense.
Section
3.
Just a minute.
Of railway property unlawful possession.
Section 3. What it says?
Whoever is found or is proved to have been in possession of any railway property reasonably suspected of having been stolen or unlawful obtained shall, unless he proves that the railway property came into his possession lawfully, be punishable for the first offense with imprisonment meant for a period which may extend to 5 years.
Okay, now what happened to you? What is the prosecution's case?
Well, the prosecution case is that the railway materials, theft materials, have been recovered from a scrap dump of the belonging to the patient.
What are the prosecution witnesses?
Whereas, my lord, the dump where dump is located, the land is belong to some other person, my lord, who claim himself in his defense witness that is his property.
Property land is him. Did he say that this scrap is being run by me or in my property somebody?
And that land was, my lord, rented out to one person, my lord.
Who are you? According to prosecution, who are you?
I am my allegation is that I have stolen the property.
No, according to you, it was recovered. According to that, let us plus understand the prosecution case. Then we'll come to your defense. According to you, what is the prosecution case? That you have from your possession it has been taken.
Yes.
Any place they prosecute that this is a dump of somebody or it is from the normal possession of what is their complaint?
Dump, scrap them.
They say scrap them.
Yes.
Scrap them of you. They say they scrap them of you. Okay. And how they have any special provision for any presumption and all?
No, my lord.
No,
There is no provision.
no presumption. It's a beyond reasonable doubt.
My lord.
Okay.
And the search made, my lord.
Hmm.
Section 11 says, my lord,
Hmm.
of the Railway Protection Honorable Act. Kindly have perused, my lord.
Section 11. Yes, Mr. Day.
Hello.
And any others, not day, that day. What are your methods? Long hearing may not be possible today.
42 and 43, Lord. Here.
Supply.
Mainly.
That's why I'm asking, you are waiting. 42 and 43.
Yes, Lordship. There are
Inside
two-
jail.
Yes, Lordship. Two widows has been.
Not inside jail.
Huh?
They are not inside the jail.
Not inside jail.
Two Lordship has remembered, I think, the two widows will be raped by two of their cousin brothers, Lordship. Their
Okay,
relatives,
okay,
that
okay.
case. We are already outside the.
You are already outside. Be there for some time, 2017. I thought this is jail appeal. Jogesh sir is, I think, inside.
I am for as
Ah,
an
but
amicus
he's
curiae,
outside.
He is outside.
Oh, if it is outside, we will take up after vacation. After Bihu vacation.
After we-
43.
Same
What?
matters, Lordship.
Same matter. And who is 44?
44.
Common is inside or outside?
He is inside. 7 years imprisonment, 10 years, my lord, almost.
He's already 7 years.
I won't take much time, my lord, because
It's a case of acquittal or no, but appeal ultimately you'll have to, you may not take time. We'll have to write everything. It's a valuable right. It's not like revision.
that's
Isn't
why
it?
his pleadings is concerned.
What is your opinion? It's a good case, bad case?
Bad case.
Bad case. Okay, then it can wait. If it is a good case, I'll even take today. People should not be inside unnecessarily. If you we believe this, you will definitely say the correct things.
Obviously.
You, huh? No, it is give a little bit early. Inside.
Deliver body.
44.
You can have it tonight.
If possible, we may give it before vacation also.
Right.
We'll try once.
Okay, look into.
2-0 will try once.
Okay.
He let him at least have the satisfaction that his case is hard. Is not it? Otherwise, suppose we acquit him after 10 years is over.
It's two double toss. Certain is.
Yes, sir. Kya samadhan hai? Yes, Dev, what you say?
My lord.
According to he says that it is not my Gambura comes and says that this property belongs to somebody else, and you have not proved that this is railway materials. You have not even proved the seizure was not done under section 11. So I am entitled for an acquittal under section for 6 months.
I have already gone through, my lord, more than 1 month in jail custody.
1 month.
That may be, my lord.
Huh?
Considering that aspect, my lord, period undergone, my lord.
Period undergone.
My lord.
6 months.
Matter is there.
My lord.
Okay.
Only thing is, Lordship, that is true that these accusers have the yellow material. That is true.
We'll see. Since he's let
Yeah.
us.
Period undergone.
yes.
Period undergone.
Yes, yes.
Day after tomorrow. Period undergone. Day after tomorrow.
Okay.
I am deeply aware.
Yes. Oblige, Lordship.
Yes, Ahmed, what is this?
That matter, yes, day before yesterday, Lordship heard that he went as a proxy to the examination hall. That matters. My case is that, Lordship, that allegation is that I have written the examination on
But there
behalf
is-
of other person. So that FSL was not, it was not sent to
So
FSL.
whether it's me or
anything else,
only on confessional
yes,
statement.
and interestingly, the other person, who is my brother, Lordship, on behalf of whom I went there, he is not the accused in charge sheet or FIR. Subsequently, he was brought as under 319 and he is acquitted.
Day after tomorrow. কথা কর huh? Yes, everybody is waiting.
Yeah, in this case, under section 353 of the IPC, my lord,
Initially, trial court convicted me for 1 year with fine.
Then
Then I filed appeal, appeal partly allowed. It was reduced to 6 months, my lord, with fine, my lord.
6 months. What is the minimum?
Minimum, my lord, from fine can be done.
Only fine.
Daily wage level. My allegation is that one constable, the accused has hit one constable is stone, my lord. But actually, in the evidence, my lord, he actually not identify. As the chief, he said he identified. As the cross, he said
He said
the
to-
villager.
That somebody hit him backside.
Yes.
Somehow I dealt with this case earlier. Huh? I think this is a case of acquittal, both of us. He said in the sieve that yes, I was beaten up but he subsequently said somebody hit me behind and I could not identify. The main witness says I could not. So there is a doubt whether this is the man or there are some other people.
Initially, my lord, there are on the same day, my lord.
Another
If I
incident,
there are two incidents on
Ah,
the
two
same
incidents.
day.
Ah.
Initially, my lord, they were on duty along with some other person, other constable, and later on, my lord, after
Okay,
that incident.
if you want an acquittal, honorable acquittal, we'll have to give a patient hearing to Mr. Bothakur. If we'll convict you, then we'll have to give you a patient hearing to you. Isn't it?
Yes.
Not today. Done our part. Today's part is over. Sorry for keeping you waiting. When? This is 2013. January 1st week or you want before vacation?
Your lordships.
10th of January.
All right.
Yes.